Welcome. In this video, we will discuss about the MLC who was disqualified for being appointed as a minister. So in this video, we will discuss about the 10th scheduled. We will discuss about the articles in constitution according to which he was dismissed or he was disqualified from being appointed as a minister. So we will discuss the present context, we will discuss what led to it, and then we will go into the constitutional provisions related to it. So let's start. The Karnataka High Court has held that Vishwanathan stand disqualified under the anti-defection law and hence cannot be inducted into the state cabinet. So this is the present context that Karnataka High Court has kind of state the disqualification of the minutes of the person known as Vishwanathan, who was disqualified under the anti-defection law. So anti-defection law in India prevent the people to change their parties when in the government, and it kind of holds a ground for disqualification. So the High Court held that A.V. Vishwanath has incurred disqualification under the Article 164(1)(b) and Article 361(b) of the Constitution. So this is what the High Court highlighted, that the Article 164(1)(b) and Article 361(b) of the Indian Constitution does not allow for the appointment of Mr. A.H. Vishwanathan to be appointed as a cabinet minister. So this is the context. So what was the issue? A petition was filed in the court alleging A.H. Vishwanathan had been appointed as the member of Legislative Council for the sole purpose of making them minister, despite the fact that Vishwanath had lost the by-poll. So this is the context. A petition was filed in the High Court which says that A.H. Vishwanathan should not be allowed to become a minister because he neither has won the by-polls and he was disqualified. The petitioner argued that he was still disqualified as per the Supreme Court judgment on November 19, which upheld former Assembly Speaker Ramesh Kumar's orders for disqualification. The plea maintained that a disqualified member can become eligible to hold position of a minister only if they won the by-election from the same constituency. So this is what is mentioned in the Constitution, that if a member has been disqualified under anti-defection law, then they could be re-elected or they could be made minister when they won the election from the same constituency seat. So this is the issue, or this is the petition in which the Karnataka High Court has upheld the disqualification of Mr. A.H. Vishwanathan. Now these things are important for you to kind of develop a context or to understand why we are discussing about it. But from your polity perspective, what is more important is your articles in picture as well as what is anti-defection law 10 scheduled as well as the ground for disqualification. So let's discuss about them now. So let's first discuss the Article 164(1)(b), which was mentioned by the High Court judge while giving his judgment. What is there in Article 164(1)(b)? It states that a member of Legislative Assembly of a state or either house of the legislature of the state, which means maybe it is a state legislative assembly or it is a MLC. So it doesn't matter if it is an MLA or an MLC, both of them could be disqualified under the Article 164(1)(b). Belonging to any political party, if disqualified as a member of the assembly, shall also be disqualified to be appointed as a minister for the period of their disqualification. So this is what Article 164(1)(b) says, that if a person is disqualified under the anti-defection law, then for the same period they cannot also become a minister. So member who is disqualified under the anti-defection law or remains disqualified for the period till that period is reduced or that period is done away with, they cannot also become a minister. So disqualification to being a member also means disqualification to being a minister. This is the major content of Article 164(1)(b). Now let's also see the Article 361(b). So a member of a house belonging to any political party who is disqualified for being a member of house under the paragraph 2 of the 10th schedule, which means under the anti-defection law, shall also be disqualified to hold any remunerative political post for duration of the period commencing from the date of his disqualification till the date on which the term of his office as such member would expire, or till the date on which he contests an election to a house and is declared elected. So this is something which has been highlighted in the recent judgment, that he lost the by-election, so that it means he is not able to contest the election to the house or was not able to win it, which means his disqualification is still in effect. And this particular article 361b says that during the time of disqualification they cannot hold any remunerative post. So this is something which is the matter content of the article 361b. So article 164 clause 1b and article 361b are the one which was invoked, or which were actually the contentious point in the present case. Now let's quickly understand about the 10th schedule. So the 10th schedule was inserted in the constitution in 1985 by the 52nd Amendment Act. So what happened during the time of 1985 Rajiv Gandhi government? It was found that many people are changing party in order to get more remunerative posts. So there was this major dialogue like Aya Ram Gaya Ram. So he actually changed party within hours. To stop such kind of behavior, anti-defection law was put into picture, and it inserted a new schedule in the constitution known as the 10th schedule. It lays down the process by which the legislators may be disqualified on the grounds of defection by the presiding officer of a legislature based on a petition by any member of the house. So any member of the house could actually raise a concern to the presiding officer, which is speaker in case of Lok Sabha and chairman in case of Rajya Sabha. So any member of the house could raise a concern that this person has been like going against the ethos of the anti-defection law, and the presiding officer could decide. The decision on the question as to disqualification on the ground of defection is referred to the chairman or speaker of such house, and his decision is final. Now this is an important thing, that the disqualification under the anti-defection law is decided by either the speaker or chairman of the respective house, and in that case their decision is final. But this particular statement was later in 1992 by an order of Supreme Court. It was said that the judicial review for these act is still available. Like if the act or the disqualification seems like arbitrary or malfeasance in its nature, then judicial review is available to the decision taken up by the speaker or chairman. So this was decided in 1992 Supreme Court case. The law applies to both Parliament and the state assembly. So right now, for an example, today we were discussing the context of Karnataka Assembly. So it is applicable to the Parliament as well as the state assemblies. Now, what are the grounds on which a candidate or a member of a particular house would be disqualified? So it mentions certain conditions for disqualification. If a member of a house belonging to a political party voluntarily gives up the membership of his political party, or votes or does not vote in the legislature contrary to the direction of his political party. So this is the thing. So these are the two conditions, like voluntarily he have been elected as a, for an example, to be a member from a party BJP, but then he voluntarily gives up the membership of the BJP. In that regard, it could be considered as a ground for disqualification. Similarly, there is a concept of party whip, which says that a person who belongs to a particular party needs to follow the wish of the overall consensus of the party. So if they are not voting, or if they are voting against the wishes of the political party from which they belong, it could also lead to disqualification. However, if the member has taken prior permission or is condoned by the party within 15 days from such voting or abstention, the member shall not be disqualified. So at the end of the day, if it's like the member has not voted or voted against the wishes, if he has taken prior consent, or if the party has within 15 days, if the party does not find it any problem with it, so he will not be disqualified. Then the other ground is if an independent candidate joins a political party after the election. So if an independent candidate who won because he was belonging to he fought independently and then he later joined as a member of a political party, that could also hold as a ground for disqualification. And finally, if a nominated member, so we know that president nominate 12 members to Rajya Sabha and two to Lok Sabha. So, in that regard, those nominated members join a party 6 months after he becomes a member of a legislature. So, it's like that, for an example, somebody joins the Rajya Sabha as a nominated member in January. As a like they have been nominated because of their contribution in the fields of art, literature, science, and social work. So if they have been nominated from those fields, and maybe in September if they decide to join a political party, if they decide that I will go ahead and join any political party, so this will become a ground for their disqualification. So just remember that these are the ground of disqualification which has been defined in the anti-defection law. So I hope you have understood this video. This topic is important from a polity perspective. Know the content of the articles, which articles are in question, then the 10th schedule, what are the grounds of for disqualification, whether judicial review is allowed for the decision made by the presiding officer of the house, and other such updates which has been happening in the Indian polity. So if you have any doubt, feel free to drop a comment. Thank you.